Welcome back, my fellow patriots, to Save Our Republic Daily video series. We've been reviewing some fundamental documents important to American history and our freedoms and liberties. Today I'm going to continue that trend with discussing a court case. And don't worry, I'm not going to discuss or read and recite the entire court case to you like I've done with some of the other documents, but I'm going to give an overview of it, and it's a very, very important case. It's perhaps the most important decision ever issued by the United States Supreme Court. Marbury versus Madison. It addressed the issue of whether an act passed by Congress that conflicts with the Constitution was valid or whether it could be struck down by the United States Supreme Court. The law at issue granted the United States Supreme Court original jurisdiction to hear a case. Now, original jurisdiction means that parties can bring a lawsuit right before the Supreme Court. They don't have to go to a trial court or any lower courts. Normally, the Supreme Court is an appellate court, which means that you have to start at a trial court and appeal decisions before it makes it to the Supreme Court, and the Supreme Court can choose to accept or decline those appeals. The Constitution lays out a few limited areas of original jurisdiction. For example, conflicts between the states or a conflict between a foreign government and the United States. There's some others. And what Congress did in the Judiciary Act of 1789 was to provide another area of original jurisdiction to obtain what's called a writ of mandamus. A writ of mandamus would be an order by the court ordering a governmental official to fulfill his or her duty. So, for example, you did everything you're supposed to do to get a driver's license, and it doesn't matter, the Secretary of State doesn't give it to you. You could go to a court and say, order that I get the license. That's what a writ of mandamus is for. It's a very limited and narrow remedy. And in this case, someone who was nominated for a judgeship and who'd been appointed by President John Adams brought the lawsuit because although he had been nominated and appointed by John Adams, there was a piece of paper that was required to be delivered for him to actually get the judgeship. And because of the transition that happened between Adams and Jefferson, his successor, that piece of paper was never delivered. And so Jefferson refuses to deliver it because he said Adams did this after he lost the election. They were called the Midnight Judges, and he didn't think that he would further undermine the federal judiciary by completing the appointment process for people that John Adams had nominated and been appointed by the prior Congress who had been defeated in the what he liked to call the Revolution of 1800. So Jefferson refuses to provide the necessary paperwork for the nominated judge to be seated, Marbury. Marbury sues Secretary of State James Madison. Madison is now the Secretary of State under Jefferson because it was Madison's duty to deliver the paperwork. And the federal government was very small, so they decided to give Madison that duty, the Secretary of State. And there was an opinion that was written by Jefferson's distant cousin and nemesis, John Marshall. And the Supreme Court found that the law granting the Supreme Court the authority to hear the case was unconstitutional, and it dismissed the case. John Marshall, the Chief Justice, first explained that, quote, the government of the United States has been emphatically termed a government of laws, not men, unquote. You might say, well, wait a minute. I thought we were a republic or a democracy, so it's people that make up the government. I don't understand why we would say it's laws. Well, the idea of the rule of law, which I've covered in prior episodes, is that the law, once it's passed and enacted, is what governs, and that the personal desires and predilections of the particular people in office shouldn't matter when they're executing the law or enforcing the law. And so no man is above the law is kind of the counter to or this complement to this idea that we are a government of laws and not men. So if you're still a little confused on the rule of law, go back and watch the rule of law video that I produced in this series, or go to patriotweek.org and look up the first principle, the rule of law. He continues that under the doctrine of separation of powers and the inherent judicial power of the Supreme Court, that the Supreme Court is the final decision maker of what the law means. Quote, "It is emphatically the province and the duty of the judicial department to say what the law is. Those who apply the law to particular cases must of necessity expound and interpret that rule. If two laws conflict with each other, the courts must decide on the operation of each." Unquote. This is the very essence of judicial duty. So when somebody comes before me and there's a lawsuit and an interpretation of a court rule, a statutory provision, a rule of evidence, I have to figure out what the law means and then apply it fairly and impartially to the facts that I find before me. Before the Constitution was the paramount law of the land, because the Constitution was the paramount law of the land ratified by the people, Chief Justice Marshall found that Congress could not alter it through mere legislation. Quote, "It is a proposition too plain to be contested that the Constitution controls any legislative act repugnant to it, or that the legislature may alter the Constitution by an ordinary act." Unquote. In other words, the Constitution is the supreme law of the land. Congress can't pass laws that contradict it. For example, we all know that a president can only serve 4 years and has 4 years to serve. Congress can't pass a law that says a president's term ends after 2 years or ends after 12 years. The Constitution would conflict with that, and the Constitution would be supreme. Chief Justice Marshall continues, quote, "Between these alternatives, there is no middle ground. The Constitution is either a superior paramount law, unchangeable by ordinary means, or it is on level with ordinary legislative acts, and like other acts is alterable when the legislature shall please to alter it." Unquote. So again, the Constitution is supreme. Laws that conflict with it must fall. Those who oppose judicial review, Marshall explained, quote, "would subvert the very foundation of all written constitutions." Unquote. Such a theory, quote, "reduces to nothing what we deem the greatest improvement of political institutions, a written constitution." Unquote. I have mentioned in prior episodes that the idea of a written constitution was really quite revolutionary when we adopted our Constitution. There was an unwritten constitution in England defined by traditions and a few legislative enactments and customs and prior court cases, but there wasn't a comprehensive constitution written down that everyone had to follow. And we decided when we declared independence that all the states adopted separate written constitutions, and then we adopted the first constitution, the Articles of Association, and they were written down, and then we adopted the current federal constitution, and again, it was written down. A revolutionary way of looking at government, and he's saying we did this for a reason, which is that there's this paramount law written down, and we need to enforce it. Thus, Marshall continued, quote, "The particular phraseology of the Constitution of the United States confirms and strengthens the principle, supposed to be essential to all written constitutions, that a law repugnant to the Constitution is void, and that courts, as well as other departments, are bound by that instrument." Unquote. Marbury versus Madison established the bedrock principles that the Constitution would govern the affairs of the government of America, and that the Supreme Court would be the guardian of the supreme law of the land. Until next time, don't forget about America's Survival Guide at americasurvivalguide.com, Patriot Week at patriotweek.org, and the Patriot Lessons American History and Civics podcast. God bless you, and God bless America.